Today we're going to be talking about citizen lawsuits, specifically around how to prevent, litigate, and also settle Clean Water Act citizen lawsuits. A little bit of background, Clean Water Act is the overarching law for these lawsuits. And today we've got a guest on, Nathan Metcalfe, who's a partner at Hanson Bridget. He's going to be talking about some of the background on why these citizen lawsuits happen. Background on Mapentry, so we like to think about ourselves as stormwater permit compliance for the internet age, so bringing digital tools into stormwater compliance, and this is especially important around citizen lawsuits. If you're looking at ensuring compliance, whether you're on one site or many sites, that the paperwork gets done, that you're actually reviewing the data. These are some of the things you'll see in Nathan's talk, and I'll touch on is you can't just collect stormwater samples and forget about it. You can't miss inspections. You can't miss reporting. And one of the things from a software perspective we can do is we can automate a lot of this, checking a system of checks and balances around it to ensure that you're actually in compliant with stormwater permits and hopefully avoid some of the lawsuits out in this industry. So quick background on our software. This is what a dashboard would look like. So if you're doing or if you're managing permits on multiple sites, one of the important things to staying out of litigation is making sure you're actually collecting the samples you need to and doing the reporting. So on the left-hand side are all your locations, and those red dots are warnings. That means something's been missed, a BMP hasn't been fixed, an inspection hasn't been done. And then if you look at the exceedances, it'll automatically calculate when you're starting to trend over. And this is one of the biggest factors out there from a litigation perspective is if you go over benchmarks or action levels, it's one of the big reasons why environmental groups will come and file citizen lawsuits against you is for exceeding the different benchmarks action levels. Doubly important is following up on BMPs. So if you have exceedances of benchmarks action levels, you got to make sure you're actually changing your BMPs and following up and not just doing an inspection and forgetting out about BMPs. And that's what you're seeing on the corrective actions, that middle tasks section. So that's a quick overview of our software platform, and it's used by companies all over the US to ensure compliance with stormwater permits and avoid these kinds of lawsuits. The other pieces of the business, software, we can do a lot of things very efficiently, automate a lot of the stormwater program. The other piece is educational content training, so staff training. We're going to be putting out a lot of material pretty soon around staff training in terms of making sure your facilities actually know what's going on. Kind of like these webinars today. And then services, we get involved in litigation if you get into that as a technical expert, and then also just BMP design and dealing with those exceedances. So those are the three components of Mapentry. Give you a little bit of background on our guest today. Nathan Metcalfe is a partner with Hanson Bridget. Nathan and I have worked together over a number of years on different stormwater litigation cases. He's got a vast array of experience in this, especially around industrial stormwater, but also in the municipal stormwater. Background on citizen lawsuits from big picture, like where we are and what we're seeing in the industry today. So we routinely pull notices of intent to sue, which are the precursor to a lawsuit for stormwater permits. And over the first 3 weeks of July, so looking back on those records, in California, 33 notices of intent to sue were filed in California. That's an incredible increase. It usually is like 1 to 2 per week in California get filed. We're talking 11 per week on average over the first 3 weeks of July. And what really triggered that was in California with July 1st, you had the response level moving up. So facilities that were in baseline that had exceedances throughout the year, July 1st, they'd move to level 1. And if they had been in level 1, they would move to level 2 if they continued to have exceedances. All these things really triggered a number of notice of intent to sue, which are those precursors to stormwater lawsuits. And it really reflects a change across the industry of environmental groups who are typically filing these lawsuits to really spur them on and file even more and more. So this is something that's a growing trend. It's not going away. It's getting more and more prevalent in the industry. So it's really worth paying attention to, understand how they come about and some strategies to potentially avoid them. But if you do get into it, how do you respond? Don't just throw away those pieces of paper. The stormwater litigation as a whole is a trend across the US around settlements for these, and these are some of the data here, but I'm going to dive into a couple things because there's a few things really driving stormwater lawsuits, even outside of California. One of the things to note is, number one, EPA enforcement priorities. So every couple of years, EPA picks some national enforcement initiatives. Industrial water waste is one of the number one enforcement priorities. And this is important in a stormwater lawsuit context because a lot of times when companies get those notices of intent to sue or lawsuits, you often can look back a year or two and see that they were inspected by a city, a county, a state, or a US EPA, and there might have been some violation. Those violations, those inspections will often trigger a lawsuit down the road. It's a pretty common problem. And we're seeing EPA doing more and more inspections. We're seeing them look at specific industries around plastics. We're also seeing them doing inspections with the state agencies. So up in Oregon, US federal EPA and Oregon are doing joint inspections is what we've been hearing from facilities. So it's something to pay attention to if you do get inspected at EPA, water board, state agency, city. Make sure you fix any violations very, very quickly because that's often a precursor to later litigation or lawsuits. The other thing is electronic reporting. So EPA in December 2016 is mandating electronic reporting from the states. That's trickling down to the different states saying that facilities need to start reporting stuff electronically. What electronic reporting does is puts more transparency on the status of stormwater programs across the US. And that is also forcing environmental groups to be able to see this data. It's easier for them to access because it's all electronic, it's all online. And that too is driving this increase in stormwater lawsuits. So a couple of big things to know out there of kind of what's the background and what's driving all of this. But that's what's driving a lot of these lawsuits, and we only expect it to increase going across the US and also as we get later and later into permit cycles in California. The final thing to know from a politics standpoint is in the current administration, there's the perception that EPA is getting pushed down and budgets are cut and there's not as much enforcement. That's kind of been the public message out there. That has driven, on the flip side, environmental groups saying whether there's a real or perceived gap in enforcement or funding for EPA to increase their enforcement themselves under the Clean Water Act and under citizen lawsuits. And they've been very public about this, that they are going to fill that gap with citizen enforcement. So the political environment too is driving a lot of these because environmental groups will use it as fundraising tactics. They will use it as a way to rally their base and their network, but also just to drive money-making operations around that and to file Citizen Act lawsuits around any kind of perceived or real shortcomings of environmental enforcement. So a couple reasons why companies get sued across the board. Sampling data, like I said before, you really want to know where you're at as opposed to benchmarks action levels at any given time. It's one of the reasons why from a software perspective, it's front and center. You're seeing what your trends are in real time. You're not waiting till the end of the year. Or in the case of one lawsuit, 131 times they collected stormwater samples, submitted them, and never checked that they were over. And it ultimately cost them about $5 million for those 131 events. Sampling data will get you in trouble every time. Make sure you're not just taking it, submitting it, forgetting about it. Missing reports, big flag. You miss an annual report. It's often, especially with this electronic reporting, it's a big flag. But also just crappy sitemap SWIPs, goes back to this electronic reporting. It's easy to pull this information. And I almost guarantee if I were to pull SWIPs, I could tell you pretty quickly who is likely to have other problems in their stormwater program, just looking at the quality of their sitemap and SWIP. Is it robust? Is everything there? Has it been updated at least on an annual basis? So if you have a stormwater program, you're concerned about any of this, let me know. We often will do a free audit and kind of look at your data and what you've got and give some recommendations. So feel free to reach out if you're concerned about kind of top level program review.
So this is obvious, how to prevent compliance with the general permit. Again, they're going through smarts. They're looking for issues that trigger them to look deeper. If what you're presenting on smarts shows hopefully no compliance issues, they probably aren't going to waste their time looking to see if you're hiding something. If everything looks to be upfront and in compliance, if you do have issues, address them. Say, hey, we're in exceedance level 1, and here's here's all the stuff that we're going to do. You can add additional stuff to your file other than just your annual report, or you can flavor your annual report any way you want to. So what I tell clients is, if you're filing something within Smarts, make it look as good as you can and deter somebody from digging deeper. They don't want to go through the hassle of looking deeper for somebody who looks like they know what they're doing. They'll move on to somebody that's easier picking. Another thing to help is staff that is trained, that can recognize these issues, help resolve issues, make sure that your documentation looks good. Again, a good consultant, if you don't have internal staff at the appropriate level. Current useful SWIP, constantly implementing BMPs. You want that record to look like, if you had an issue, we addressed it. It got a little better, but maybe not good enough. We addressed it. We did additional steps. And then we've talked quite a bit about it. Use that 60-day notice to your advantage. Reach out to the opposing side, start settlement discussions, resolve as many issues as you can, so that there aren't ongoing violations. And that's, it's kind of simple, but that's really what, it's two things: compliance and optics.
It's meeting the permit requirements, but it's also around optics and making sure things are set up correctly for your program. And I summarized a little bit more from an operational, and kind of building on what Nathan said, is make sure you're staying organized, that you've got all your things lined up, that you're following through with like corrective actions. If you find deficiencies, follow up with them. One of the best places for that to start is training staff. Make sure they understand that they can spot deficiencies, but they follow through with it and build that case against a potential lawsuit. From an operational perspective, we see it all the time. Companies get a 60-day notice and they kind of blow it off. Don't treat it like a normal business legal letter that somebody has a complaint with you, because the environmental groups operate in a slightly different way. They're not just going to go away if you write back to them saying, "We're good, thanks, go pound sand." They're going to stick around because that's their business model. So don't really take letters seriously. The other thing I would say, having seen it, is you really need somebody that knows this stuff really, really well. Not all environmental attorneys, and certainly not all attorneys, understand the dynamics of this. And I think Nathan raised a good point, is like he knows a number of the opposing counsels. He's got familiarity with these groups. He can pick up the phone and really get down to it, because ultimately it's going to be a business decision, and 95% of the time you're going to settle. You really want to have that insight. So be careful in who you select for your attorney, and this really gets somebody that understands stormwater lawsuits.